Welcome to the Estates Made Simple podcast with Jenna Carvello and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Hello, everyone. Welcome to another exciting episode of Estates Made Simple. Gord, excited to talk to you today and hear your thoughts on lots of interesting issues. How are you?
I'm doing well, and always looking forward to our chats. This is not an exception to the rule. Yeah, we talked about what can you bequeath on death as the general title for this podcast. So talk to me a little bit about how you would answer or frame that question.
Well, a great question, Gord. So I would say, you can bequeath things that fall into three categories: your assets, your body or your remains, and your family with some conditions. So we just wanted to talk today about how to do those three different parts and considerations of what to make when you're establishing a will, and also if you're acting as an executor, what you need to look for when you're dealing with someone's affairs and what can be gifted upon death and what cannot.
Yeah. And if you think of those, I think in terms of these are categories of decision making, right? In terms of that you are relevant with regard to the estate, because these directions are going to be impacting the people who you've designated in various roles, including the executor, right? So on that first one, if we're talking about what to do with one's remains, so you can certainly an executor should needs to make some decisions, and as we've highlighted in other podcasts, sometimes one of the very first decisions that an executor is thrust into is, well, okay, show up at the funeral home. What do we do, right? Is it cremation? Is it burial? What happens? And what if the person wasn't specific with regard to their wishes? What do we do in those regards? I just want to expand that a little bit, because I think over the years I've had increasing conversation about organ or tissue donation, in addition to, well, what do we do with the body? And so the will is a place where you can express your wish. Let me just, before I forget, say if that's where you're gonna express your wish, you want to make sure your executor knows where that document is, because if they read the will after they're finished, after the funeral, and they've already made decisions, it's kind of a little late at that point, going, oh shoot, I should have looked at the will. Thankfully, I think funeral directors and other people involved in this aspect of estates are pretty good at saying, well, you better check, go find the will. But sometimes even where the will is problematic, right? Can we get it? What does it say? And sometimes, the disposition of remains, any celebration of life or a funeral happens fairly quickly. And so just knowing where these documents are becomes really important. So a lot of times we'll get calls from people going, oh, what does the will say? I'm on my, I'm driving on the way to the funeral home. So if you know that the lawyer has a copy, is the trusted person to share some of this information, that's good to forward to your executors in advance. But let's talk a little bit about sort of specific organs or even tissue. What's interesting is if you look at the legislation, there is legislation governing this, and there's actually, in doing a little bit of preparation for this, we can distinguish between organs and tissue. And I'll get to where that can have a practical impact in a moment. But looking at sort of what the Alberta Health Services has on their website, they give examples of organs, which is sort of what we normally think of as like heart, lungs, liver, kidney, pancreas, small bowel would happen to be the examples they give to say, well, those are actual organs within your body, whereas tissues are your eyes, skin, heart valves. I wouldn't have thought that was a tissue, but they, apparently it is connective tissue and placenta. So what was interesting about that is like, oh, I didn't even know that. But it also brings up some direction to say, especially as people get older, they think, well, there's nothing good that's left, right? It's all used up, and somebody's not gonna want my heart if I'm a 86-year-old and I've had a bunch of health issues. Who's gonna want that? I've worn it out in my lifetime. So who's gonna want that as a donation? Which is fair. Usually you think of the organ donation in the context of younger people passing away and then donating their organs, and they're all in still good shape, and we haven't abused them through a long life. But it's interesting with the tissue, that is not necessarily age specific, right? I know there was a client of mine that consented on behalf of his dad for the use of some of the cells in his retina. So in the eye, they were able to go in and extract some cells, or whatever the tissue, as part of the eye. And following his death, he gave sight to 4 different people, which I thought, how cool is that? I would never have thought that. And it just shows that we don't know, we're recording this in 2024. If you're listening to this episode 10 years later, maybe that list is expanded. So there may be lots of usefulness, even if you go, hey, I got a tired old body, with regard to that, right? So that it was an example of an eye. Or you can say, well, take some of my skin to help a burn victim. That could be very meaningful if you do that. So there are ways in which you can express your wishes. So one of them, as we talked about, you could certainly talk to your family about it. As part of the conversation with your lawyer, you could say, I want to put that in my will, right? So as an executor, you want to read to say, is there a will, or even a letter of instruction? Sometimes people will have a side letter of instructions about all the details they want with regard to the celebration of life. Make sure you play this song, or invite these people, or this is what I would want to have happen. So I think that whatever communication makes sense is good, but then you can also register your wishes. So the Alberta government does have a registry, so you can do it completely online, and you just pick, well, I want to donate this, I don't want to donate that, and it'll be both organs and tissue with regard to that. So I guess one of the messages out of this is, don't presume that, there isn't anything worthwhile left. If you're getting on in years, that there might be. Right. And then do some research on that. And maybe it feels good to do some planning, and then talk to your family about it. Because I do know that if there's any contention with regard to all this, I don't think Alberta Health Services is going to sort of force a decision or look at taking tissue or organs if there's objections with the family. So I always stress, if you have a strong opinion, record it in various ways, but just make sure your family's on board with this, right? And talk to them about your wishes while you can. So you want to check all those different sources. A lot of people now are, when they're renewing their license, their driver's license, will put check the box that allows a little heart to be on the driver's license. So that's another example of where you could communicate, but you can also do it in a more fulsome way, is more than just a yes, no. You can get into the particulars, and it's good to have a conversation with your family and record that, so that your executor or administrator will actually carry out those duties, and they can do it in a timely manner, because decisions have to be made quickly, right? So this really lends itself to advanced planning, just expressing your wishes and giving some thought to it, and making sure your executor knows your wishes.
Well, those are some good points. And, it reminds me of a story which many of our listeners may have heard of already. But Gord, have you ever heard of the sour toe cocktail in Dawson City?
I have heard of that, but probably not the story behind it. So I want you to share that with me.
Of course. So for the benefit of our listeners, in Dawson City, you can actually go to a bar and order a sour toe cocktail, which is similar to what it sounds like. They're mummified toes that go into a shot of liquor. And when you take the shot, you have to let the toe touch your lips. So actually, my dad was there a few years ago, and his goal was to just get a really short toe, so it didn't touch his lips for very long. But some of his friends had really long toes in their shots. But I think the story behind it was that somebody had lost their toe in a hiking or some sort of travel accident, and put it in a shot and essentially enjoyed their shot with their toe in it. And since then, toes have been donated for this very purpose. And one of the gentlemen who was running this program, when he passed away, he donated all 10 of his toes to be used in these sour toe cocktails. So I thought that was fitting to share in our thing today, because, Gord, if you pass away and you want your toes sent somewhere, it's a good option.
I'm feeling the need to amend my will to include some specific direction. Not sure my wife would agree to that or see the utility in that, but important to have those conversations, right? And to set that out. The other thing is sometimes, you also want to research the procedure. It reminds me that I've had clients who said, well, I want to donate my body for, to the medical school, so they can use me as a cadaver for training new surgeons, right? But there's an implication to to that. I had a client investigate it and then realized, well, they said, well, you can use the body and then give it back to me and then we'll cremate it and then intern the ashes. But the medical school said, no, once you give it to us, then we dispose of it. We're not going to call you and you have no control over it. You have to sign over the body. So at that point they said, well, then I'm not going to donate my body because I don't like that. I don't think that's going to bring closure for my family. But the good news of that was because they investigated those procedures, they were able to make an informed decision in advance with regard to that. But it required them to, investigate this general concept of, I want to support a local medical school. What they had to do is talk to, in this case, University of Calgary to say, well, what are your procedures? And just sort of think that through. So that would be another example if you're looking at saying, I want to support scientific research or any other activity associated with your body. There are some choices there, but there's might also be some restrictions or some caveats on that you'd want to think through to see, does that still make sense?
Absolutely. And I think that the next category we wanted to touch on was bequeathing your assets in your will. And I know we've chatted before about what types of assets actually fall into your estate, and therefore you're able to decide where they go. But essentially, it's anything in your name alone that you get to decide where it's divided when you pass away. So that could include any bank accounts, investment accounts, real property in your name alone. It could even include shares of a privately held corporation, which we wanted to note during our discussion today that it includes the shares of the privately held corporation, but it may not necessarily include those assets in the corporation because you own the shares, but there could be other shareholders who also have some ownership. So it's important to distinguish between the two. And it can also extend to genetic material like sperm and ovum, as well as digital assets. So it's really important as an executor to really think about everything that the client or that the testator may have owned to be able to properly deal with it in the will. And that brings to mind an example. I was at a presentation a few years back, and they were bringing up a case that individual had a Second Life persona on the Second Life platform, where you get to create an avatar and have all these different experiences online, and that avatar was worth $80,000. And so it just goes to show that you never know what assets are valuable.
Yeah, indeed. And how do you manage those, right? So yeah, the theme certainly is you can only give away what you control or what you own, and then you've got to make some decisions, and clarity is required for that, or you're just handing over a bit of a mess to the executor or the administrator, right? Trying to figure out all those, the implication of your generally stated intent of this is what I want to do, right? And the more complex the asset, the more I think you have to investigate what are the conditions on that. Is it, what are the restrictions? Is there third-party consents required to make all this happen? Can I actually do this? Do I actually control it? And just sort of thinking through all those questions as part of the direction you're giving to the executor, right?
Well, and if there's that brings to mind, if there's other assets in other countries, they may not necessarily fall into the estate. There could be forced heirship rules in those other countries. So it's good to have some advice in those other jurisdictions to determine if you need to actually, in fact, deal with those assets or if they're passed according to the laws of that jurisdiction.
Exactly. Or even making sure whether there's multiple wills. It's not uncommon. I'm seeing that actually happen more and more, where we're drafting like a will for assets in another jurisdiction at the same time that we're dealing with kind of the assets in Alberta, if you will, or in Canada. So just recognize that we have to identify all your worldwide assets, and then what's the best strategy to make sure they're going to go in the right place and to who you want them, who you want to receive them, and then how is it structured? Acknowledging that, sometimes people say, well, this person gets this, and my son gets this piece of property, my daughter gets that property, and the balance of the estate is divided equally between son and daughter. Well, now you've created what if one property is more valuable than the other, right?
Right.
Do you equalize for that? What, is that a relevant consideration? Just sort of thinking through those things, and then making sure, in fact, you do own them, right? Because if that land is part of a corporation you control, just saying, well, my son gets this property. Well, if you don't own it, that gift fails, right? And so then we have a problem with that. So again, clear instructions, clear directions, no ambiguity for the executor is the goal. For sure.
Yeah, absolutely.
And then lastly, we talked about sort of that category. I like how you put that, which is what can you bequeath on death, your dependents, right? So this is not, can I put my kid on Kijiji? You can't do that, if they're particularly annoying. But you can address an important part of the planning process. So it relates to something certainly that guardians are going to have to deal with, which might be the same as executors, could be different people, is to say, who's going to look after your dependents? You have an obligation. In Alberta, it's below the age of 18. British Columbia, it's 19. So check your jurisdiction for what the age of majority is. Typically within your will, you can in fact designate to say, I want this person to be the guardians, and then all the what ifs around that. Well, what if I name this couple and then they separate? Or what if they're not willing to do it? Are there alternates that are listed? So in that process, sometimes people believe that, oh, if it's in the will, that's a slam dunk. I just have to show people the will and I'm good, right? As this surrogate parent, and when I'm signing a consent at the hospital or at the school for this kid, that they'll accept it. And the answer is no. You need to get a guardianship order for a minor child, and there's a legal process you go through there. I think certainly what's important, particularly in contentious, where there might be a dispute about who's supposed to look after the kid, what mom and dad thought and looking at the will can be an important consideration in determining who the court may determine. But ultimately, because it's dealing with a child, the court always retains final say. They have the jurisdiction over what happens to that kid. I think in probably 98% of the time, it's a rubber stamp to say, of course, we'll approve that application. Everybody's, this is what the expressed wish was. But you can imagine a situation where this kind of conversation didn't occur ahead of time. And there is maybe some contention between, well, especially in a blended family, well, like who's actually gonna be involved? Who's gonna look after this child or children? So I think within the planning process as part of the will, you would normally lay out, I would want this person, which hopefully quells any dispute about what the right decision is. It doesn't eliminate it, because people could still bring an application to court saying, I don't think that's appropriate, or it's not in the child's best interest. And that's really the paramount test, is what's in the kid's best interest. But it's helpful to have your wishes expressed. I was reviewing a will of somebody who passed away last fall, and in that, it was interesting, we did a lot of this type of planning, but for their animals. They were big into the equestrian activities, and they owned, they had an acreage outside of the city, and they had horses and animals and dogs and all sorts of chickens and all sorts of animals, but had a very specific plan. Actually, the guts of it was in the will, and then they had some side letters of instructions with some detail about this is what happens with the animals, because that was an immediate issue of this person passed away suddenly, and it's like, okay, these animals have to be fed. Like, and where did they go, right? And there's some immediate concerns there. So you may have some fur children, as sometimes they're referred to, and what happens to them is that in an orderly way, done in an orderly way, having some advanced planning on that and laying out your wishes. It could be outside of the will, or some of that may be detailed. In that particular case, we actually attached some money to all that. We said, this amount of money, we want the horses to go to this person, and they're to receive a gift of this much to cover the costs associated with it, right? So that was her, but she thought that all through, going as a single person. She goes, if something happens to me, there needs to be a plan for the horses. So if you can identify that as, in your situation is, what about the beloved family pet, right? Well, what happens? You can have a fight about who has custody of the kids, but it could also be a fight about who's taking the dog. Or maybe it's, well, who is going to take the dog? And we got to,
Yes.
The fact that you had a conversation ahead of time, the person is, oh yeah, I did say I would take the dog. And then then that happens, right? But you can get creative on your planning, that if the acceptance of that request of that animal or person, obviously if that involves some costs and you want to do some planning of that, that's normally the case with children. You would say, I'm setting up a trust fund to allow the guardians to be paid all expenses associated with raising that child, because I'm no longer around. And that's fundamental to the estate planning process. So that could be, the executor might also be the trustee of those trusts, right? So that's where it kind of becomes relevant for the executors to manage those trust funds, to work with the guardians, whether it could be them, it could be a different person in terms of that. So while you don't have title to your children, if you will, like we're talking about delivering assets or donating organs or tissue, obviously you want to put a plan in place and make it clear for the executor what's going to happen in that situation for your dependents and minor children. If you have an adult child with a long-term disability, then just having a plan in place for that would be appropriate as well. And looking at guardianship and trusteeship orders hopefully are in place for that contingency.
Well, and I would argue that would probably be the most important part of your estate plan is taking care of your loved ones.
Yeah.
So what else is your estate for but to do that?
Right.
Well,
And
Gord,
on that, but maybe one last point on that, on the financial side, and we've talked about, sort of litigation and claims that can be made in a recent podcast. But if you don't do that planning or do a poor job of planning for your dependents, for your children, then there's a possibility that now an application has to be made to the courts to correct it and to make adequate provision. So again, you don't want to wish that on your executor, that they're thrust into a legal battle, because that's never fun, or just an unnecessary application to the courts. It's just going to increase costs and delay in the finalization of the estate.
Well, I think that's a good place to leave off. For all of our listeners, thank you so much for tuning in. Please feel free to subscribe to wherever you listen to podcasts, and you can see our lovely faces on YouTube if you are interested. We're always happy to hear of suggested topics for our podcast, and we look forward to seeing you next time.